California is an at-will state. Can you briefly tell our audience what an at-will state is?
Certainly. In California, employment is considered at will, which means that an employer can terminate an employee for any or for no reason, and in the same way, an employee can quit their employment without giving a reason to the employer.
Now, my understanding is, with the exception of what I refer to as the Title IXs are violating your civil rights, you can violate an employee for any reason. But for example, whistleblower, skin, age, religion, you cannot fire an employee for those Title IXs, correct?
Correct. When you are terminating an employee who is an at-will employee, meaning they don't have a contract of employment with you, what you have is the right to terminate them for any reason, as long as that reason is not of a discriminatory nature. And in California, what we have are protected classes that are reasons that are not to terminate an employee. For example, the ones that you mentioned, if someone is a whistleblower, there's race, there's gender, there's national origin, there's pregnancy, there's gender association. There are about 15 to 20 protected classes in California, and certain cities have their own protected classes. For example, San Francisco includes height and weight as part of a protected class. Yes.
Wasn't there a case a while back where an employee from Hooters was fired because she was overweight, and that was not against the law, or am I mistaken?
No, that is correct. That was a big case.
But if it was in San Francisco, then the former employee would have been compensated.
Correct. Now, if you hire an employee for a certain job, then you have the right to make sure that the employee fits the requirements for a certain job, as in Hooters, or as a better example, maybe for a driver for a pizza company. Then you have the right to make sure that the person has a driver's license and the person's licensed to drive a car, because that's a requirement of employment. And you can terminate that employee if they don't have a driver's license or if they don't have the requirements for employment. But if you terminate for a discriminatory reason, that's what you got to watch out for. Even though employment in California is at will, what you don't want to do is terminate for a discriminatory reason. For example, if one of your employees becomes pregnant, you don't want to terminate her because she's pregnant. However, you can terminate her even though she's pregnant, as long as the reason is not the pregnancy.